You don't want to restrict somebody for a decade, right? Where they can't make a living and feed their family now for 10 years.
Oh, hey, by the way, you have to sign this too. I know I definitely want to join this company, but to agree to these terms.
Everybody always has what I call the warm and fuzzies, right?
Yeah.
I mean, you're all feeling good going into it, right? It's when you get to the breakup that all of a sudden, people don't have the warm and fuzzies anymore. Law in this area was developed maybe circa the 1980s or something like that. There wasn't all of this sort of remote. I mean, you definitely had like sales territories and regional employers and things like that. You didn't have like the remote sort of capabilities, obviously, that you have now.
Once you put it out there, it's out there forever.
It's not like you're raking in so much cash that you can afford to just burn through thousands and thousands of dollars in legal fees. I can tell you what the law is on that. Can't tell you how the judge is going to rule because that's always kind of up in the air. Okay, welcome back to Unlocking the Law, a podcast where we tell authentic stories about the law, break down barriers you may have to working with attorneys, and try to explore topics of interest to businesses and communities. We try to do this in a modest way, maybe mix in a little humor here and there. And the podcast, folks, is brought to you by the law firm of Fawcett and Grisco. I'm your host, Brandon Grisco. And joining me today is Adam Klug. I've known Adam for a long time. Fun fact, we're actually recording this on Veterans Day. Adam is a veteran, so Adam, happy Veterans Day. Thank you for your service to the greatest country in the history of the world. To all the veterans out there, actually, that may be tuning in, thank you for your service and happy Veterans Day. Adam, why don't you just take a minute and introduce yourself to our viewers and just kind of let them know who you are and a little bit about what you do.
Thank you. Happy Veterans Day to my brothers and sisters out there. So I'm Adam Klug. I work on behalf of the Specialized Recruiting Group. We're also a part of Express Employment Professionals. So some areas that we focus on have been accounting and finance, finding top talent in there, and also within the construction, civil engineering industries. But experience for hiring a lot of salespeople before that and a lot of different positions across the U.S. So I'm glad to be here and interested in the topic we're going to talk about today on restricted covenants.
Yeah, restricted covenants, non-competes. Covenants not to compete, non-competition agreements. They go by many different names. But first, I just want to say you mentioned a couple of specific industries, maybe or people that you guys are looking for, like financial types or civil engineering types or engineering types. Man, I know those folks seem to be really hard to come by nowadays, or at least it feels like from talking with clients that maybe work in that space. They seem to be getting people like sort of scooped up by competitors or, just maybe having a generally kind of hard time in that industry. I mean, is that accurate?
Yeah.
Is it pretty tough in that space or?
Definitely. I was just at a meeting last week, a part of the association, mostly based in the construction industry. And right now, and listening to economists that was speaking about the industry on labor, hiring, retention, how that looks like. Obviously, we've all seen the costs go up on many things. Obviously, the costs, specifically in construction materials, the tariffs that are out there, they went out by, I think it was right, 42-45%. And so how it relates to labor on that side, it's been the lowest layoff rates in Michigan history, period. And not so much increase in job openings. So right now, that sense of just that particular industry is that there's not a large hiring push and there's not a large, layoff or, termination firing push on that side. So, everyone's kind of, staying still to a standpoint and there's more opportunity out there. But it's really, the war on talent is real. So it's tough to get talent. It's hard to find that talent. And then obviously outside of it, not only to hire the talent, bring them in, but, to retain them and keep them on your team. That's a whole different, side of the equation that a lot of companies are going through right now. And also, obviously, we've all seen probably Amazon. There's been a bunch of layoffs, out there as well, too. So it's an interesting world as we kind of, head out of 2025 and move into 2026.
Yeah, no kidding. And so I'm sure you do run into sort of the non-compete agreement or restrictive covenant or what have you You probably run into those at least here and there, if not more frequently, I would think.
Yeah, definitely. I mean, we see them a lot of the time. I mean, it's industry agnostic, really. I mean, a lot of times we see them, sales, business development, or even, key players on, executive level, hiring that we do. So, when it comes into play on the candidate side, they can be, it can cause a candidate to have a pause, right? And
Hmm.
to say, who, I have this non-compete or non-solicit, that I have to follow. That goes in the equation of saying, hey, do I even want to make this career move and join a company, right?
Yeah,
What do they want me to sign to? So
right, right.
a lot, yeah.
So, yeah, I guess let's just define our terms real quick for people that might not necessarily be 100% familiar with a non-compete or whatever. Um, and without getting too technical, I suppose, like at its core, a non-compete is essentially an agreement that you would enter into as the employee with your employer that basically says, hey, in consideration for my employment with this organization, I'm going to agree that for X number of years following termination of employment, right, I am not going to engage in a competitive business or occupation or join a competitor or something like that for a certain number of years or months. And usually there's a territory associated with that, right? Medical, dental, those are areas where your distance really makes a huge difference, right? Because people oftentimes are only going to drive so far, right, to go to the doctor or to go to their dentist. You know what I mean? So having that geographic restriction in some cases can be really important. In other cases, you might have a business that operates statewide or in a multi sort of territory, you know what I mean? A multitude of territories. And so your geographic restriction can sometimes get quite a bit broader there. Is that pretty much what you typically see, or what do you usually see out there?
Yeah, no, definitely. I see some that are, somewhat more generic, right? Don't go down into so much like, I would say city based or like territory based, more just overarching, industry and kind of what I hear a lot from, the business community, our clients, or even thinking about internally, about our team, they kind of relays back to, almost two basic points. It's, hey, if you, do leave our company, right? Don't reach out into our customers. Don't take our business from us. And
Mm.
then don't take our people. I think, at the end of the day, that's what, most companies are looking at. And then, it can go into more with intellectual property,
Sure. Yeah.
else that can come along with it. But that's kind of what I typically see. But I have seen some ones that are pages long and spell out the cities and all the radius
Yeah, for sure.
go into it. Yeah.
Yeah. So I guess I would say in Michigan, at least, um, the law follows what we would call, I guess, in the legal industry, sort of the blue pencil kind of doctrine, which is that if a court finds that the non-compete is unreasonable, they can sort of modify it in a sense to kind of make it reasonable. Um, and the law probably could use a facelift because most of the time they're talking about in terms of time, so a temporal restriction, right? You don't want to restrict somebody for a decade, right, where they can't make a living and feed their family now for 10 years, right?
Yeah.
But it also wouldn't be very useful to make it like a 2 week restriction, right? So you've got to have like some reasonable kind of time limitation on it, at least in Michigan. I think most states are kind of like that. Um, and then as far as the geography piece of it, I think is where it gets really interesting because I want to say that back when, say the Michigan law in this area was developed maybe circa the 1980s or something like that, there wasn't all of this sort of remote. I mean, you definitely had like sales territories and regional employers and things like that, but you didn't have like the remote sort of capabilities, obviously, that you have now. And so I think geography was a lot different then than it is now. And so I think whether you're the employee or the employer, um, you've got to want to like really negotiate those terms for clarity, I think, on the front end of it. Because as an example, you might care as the employee a lot less about the geographic limitations if you can sort of negotiate a favorable definition of what does it mean to compete, right,
Yeah.
with the business. So you may be able to, I don't know. I mean, there's all kinds of different ways to do this. I think from sort of an employer perspective, which is where I tend to do most of my work, it tends to be the case that you want sort of the broadest restrictions that you can get away with, right? Whereas the employee wants it to be as narrow as possible. And so you've got these competing interests, and then you've got other market sort of forces that are in play here. So for example, if as the prospective employer, you've got like a very onerous, pages long non-compete agreement with very restrictive clauses in it, and you're competing with, say, a civil engineering firm, right, that doesn't have any non-compete at all, and the onboarding process is just, and the interview process and all that is just much smoother. Well, rather than read your 15 pages of employment agreement documents, you might lose the candidate, right? And so there's also kind of those market forces in play, you know what I mean, that could also sway things a little bit one way or another. I don't know if you've seen that, like on the recruiting end of things, come up at all.
What we see most often is, okay, hey, it's throughout the interview process. The client's excited about this candidate, the candidate's excited about joining a new company. They get that offer out there, right? They might have that non-compete, restrictive covenant within the offer letter. Sometimes it's separate documents outside of the offer letter. And sometimes when a candidate's super excited about the opportunity, maybe that's not the first thing they're thinking about is the non-compete or the non-solicit when going through it. And so, it's always, looking at where are they coming from, what non-compete, non-solicit have they have, but also, it can, I've seen it be a deal breaker where it's, this offer is looking great, has everything the candidate wants, it's going to be an awesome partnership. And then, okay, hey, here's a, 3-year non-compete, or even, I've seen 4 years, and the candidate's like, whoa, like, I know I definitely want to join this company, but to agree to these terms and to be locked in this way, I don't know within the candidate, and their perspective on what they're thinking. It's like,
Yeah.
hey, do they not trust me, that much, right? Or this is how they always do business, or do other employees, other teammates, future teammates have the same agreement in place? And, not saying overarching can be a deal breaker, but it is a point of discussion has come up, and there has been times where I've seen it like, hey, I'm glad they made the offer. It's an awesome opportunity. Would want to join, but I just have to tell you, I'm like, I got to take a timeout, pause here. Let's talk about this more. And that's usually, another face-to-face meeting, or to go over, that non-compete together. So everyone on the table has a full understanding, not that it's just something after you sign the off letter on board, it's, oh, hey, by the way, you have to sign this too, so.
Yeah, that's a little maybe on the shady side to do it that way.
Yeah.
The thing is, from like a strict legal perspective, there's this concept in any agreement, right, of consideration. I don't know if you've heard of this, but consideration is essentially like a changing hands of like money or some other promise to perform some either service or payment or whatever, what have you. So anytime you do an agreement, you generally have to have some form of consideration, or it's really not binding. Okay, so obviously for employment, right, you as the employee are promising to perform services for the employer, and the employer is promising to pay you money. And so those mutual promises are sort of consideration for the agreement will make that, binding arrangement. The strictly legal rule, at least in Michigan, I think in a lot of places, is that, especially in Michigan, where you're presumed to be an at-will employee, and most of your employment application and your offer letter and different things like that are usually going to reference that you are an at-will employee. Okay. And so if the employer decides at some point in time, even after the offer letter, to create a condition of employment, say a non-compete condition or something like that, oftentimes the consideration, right, what the employer is giving up or what the employer is providing in order to make that non-compete a binding term of employment is just continued employment, right? Because they had the right to terminate you with or without cause at any time and with or without notice. And so now, by continuing to employ you, that is consideration for your promise not to compete. And so I think if you're being sort of if you don't have all your cards on the table as the business, right? I think you could sign somebody up, sort of get your hooks into them in a sense, and then, at some point down the road, be it, that week or that year or several years later, you could then implement a non-compete sort of program or roll that out. And, I think that would generally be considered legal. Um, you might have something to say about how ethical or how moral you think that is. But at least in the strict legal sense, there's not really anything totally wrong with that. Having a solid relationship and a good level of trust, and of course, on the front end of those deals, everybody always has what I call the warm and fuzzies, right?
Yeah. Yeah.
I mean, you're all feeling good going into it, right? It's when you get to the breakup that all of a sudden, people, don't have the warm and fuzzies anymore.
Exactly. And that's, and maybe a piece of advice, from your perspective as well, too. I'm always, the candidates will bring it up lightly saying, hey, I have, this non-compete. There's a time period. I might not see, obviously, the full document from time to time, just more generally talked about. And so, in your perspective, I'd be interested to know, like, what's kind of the safest way, in a sense, for recruiters to, kind of bridge that or talk about, non-competes, with clients without like crossing into any like legal territory, essentially that, could come back onto me. Is it more just kind of just relaying that information at the end of the day? Like, hey, here's a generalistic, here's what they told me, relaying that.
That's actually an interesting issue because I suppose, in a sense, I mean, I would have to look this up. I think there's a possibility that somebody could try and make out a case for like tortious interference with a business relationship or something like that. I find it hard to believe that in the general fact pattern, right, that somebody just comes to you and you're trying to place them somewhere. I find it hard to believe that there's going to be a legitimate claim for tortious interference with a business relationship or some other, sort of interference-based business case, based on that sort of factual scenario. Or I guess on the other hand, you could always get sued. I mean, anybody could just sue you. It's just like whether or not it's actually going to be legitimate, is a whole nother question. I tend to think it wouldn't be. But I think it does present an interesting issue. It's something I'd probably have to dive a little bit deeper into. But I think the gist of it, though, is that as the new employer, you've got to be a little careful because, and I think that's, again, where, some type of business interference or something like that could potentially rear its ugly head. But as the prospective new employer, how do you navigate that? Right. What's the risk reward proposition there? And I think that you might look at it and say, okay, well, I'm bringing this guy on, as a at will employee. And so if things heat up, I'll just let him go. I mean, it's like, hey, are you going to spend thousands of dollars in potential litigation if there's a threat made or if there's an actual claim filed, or if they're seeking an injunction or something like that to stop this guy or gal from working or something. Chances are you're not going to do any of that, right? You're going to let those guys duke it out, on their own dime, on their own time, and you're going to sort of move on probably to other candidates at that point, I would think. But I've had it go the other way, actually, somewhat recently, where the new employer had retained me to assist with sort of negotiating that whole situation. And then ended up working out favorably for us. We were able to sort of negotiate a limited scope. Here's what his duties are going to be at the new company, right? They don't conflict with or compete with what his duties were at the old company. He's going to be sort of in charge of a different territory. Those sorts of things, we were able to kind of work that out. And it was sort of a three-way deal because we had the old employer, the new employer who was my client, and then the employee was kind of caught in the middle, but had his own attorney involved too. And so it was sort of a three-way negotiation where we were able to kind of work that out.
I've been in kind of the middle myself before, with those
Yeah,
with
for
those
sure.
happenings, right? So
Right.
it's been really the conversation in between each attorney on both sides, and having to work that on. Usually, what we do or my team does is, that gets brought up. Obviously, we're not in a place to give legal advice like yourself. It's, hey, go
Yeah,
seek
you
out.
shouldn't.
Go. I mean,
Right.
we don't want to, right?
Yeah,
So
for sure. Yeah.
it's mostly just like, hey, go seek out, whoever attorney that you have, or, hey, we can give recommendations to someone like yourself, or, who they know out there, and have a conversation about it and what that looks like. Cause I've seen them all over the place. And like a recent example, one of my friends, and, helping them try to interview for a position. And this wasn't, the pin in the cushion, but I know the client said, like, hey, if, like, you have this non-compete. It was like a 3 to 4 month non-compete. Same industry, right? That's why I see them all pop up, is that they're moving, from the same
Mhm.
industry out to the next position. That's where
Mhm.
most of the
Mhm.
talks happen.
Yep.
But in the back of my recruiter brain, I'm like, okay, this is, 3, 4 months is like nothing, right? It takes a
Right.
while to get ramped up. Like, are you really think things are going to get skewed, or this person's going to be, based on their personality and who they are as a person, like, really violate their own non compete within those first few months? I didn't think so, but it's still a point. It still was a
I
pause.
mean, that is such a short time frame. I mean, that's like a long vacation, you know what I mean? So that's such a it's such a short time frame. I mean, it'd be relatively easy probably to ride that out in one way or another, right? Whether it's maybe like a bridge where you're working, in a different industry for a couple of months, just doing some project work or something like that. Or I mean, shoot, it might take that long just to find the new position, right?
Yeah,
Um, and at that point, I think it'd be fairly simple to negotiate, with the old employer to the extent they even became aware of it,
yeah.
within that time frame. So you see a lot of short-term kind of non-competes like that?
Yeah, they've popped up here and there over the years, but typically, in your take too, typically what I see, even just like solely recruiting in Michigan, but all across the US, like the time frame pattern is, I typically see 2 to 3 years. Like 2 years, I feel like is, I would say, standard, just going from my general sense, but it's been a lot. 2 years is the time frame I've seen on non-competes, and kind of a standard what companies have. But it ranges too. Yeah.
Yeah, I don't think 2 years is super uncommon. Maybe 18 months or 1 year would maybe be a little bit more common in my experience with respect to at least like your kind of general employee level person.
Yeah. Yeah.
Um, I think what you'll commonly see is that as you go up the corporate ladder, so to speak, you're probably going to see more restrictions or longer time frames. Oftentimes with like an ownership role, right, where maybe you had a piece of the pie and now you're moving on to other things, and so you're selling your shares back to the company or something like that. I think in those cases, you're much more likely to see like a 2 to 5 year non-competition period instead of just like a 1 year. Or even if you're, hey, I'm the sole owner and I'm selling the business, right? Totally different ball game in my view there. I mean, I think the courts are going to look at that totally differently as well. Now you're talking about somebody who, owned a business as an investment, so to speak, right? Now they're selling it, and part of the consideration of the transaction, right? The business purchase and sale is to not compete for a certain period of time. I think that's totally legitimate, and courts are much more likely to uphold longer time frames and more restrictions in those cases for sure. Where it starts to look unreasonable to a court from a court's perspective, or if it's like an arbitration or something like that from the arbitrator's perspective, is like the lower you go down the totem pole, is your business so competitive that you've got such a strong interest in your waitresses not going to work at another restaurant or something like
Yeah.
that.
Yeah.
um, Now, that was a joke. I've never actually seen a non-compete in the sort of restaurant sort of wait staff. So that was a total joke. But I think it goes to illustrate the point, right? Of like, okay, is this really serving a competitive business interest that's legitimate, or Is this just something that you do to try and kind of like, terrorize your employees into compliance or whatever, I don't know.
That's the thing, too, now with the war on talent, it's, okay, is that, trust established? Obviously, I get the point where you want to protect your business, you want to protect your assets, right? Whether that be, product, process, or people, when it comes down to it. But, with, that trust built, and having as much as not, I'm saying less restriction, but,
Yeah.
having that trust built and with that person being, somewhat least restrictive, okay, that could may not seem like it, but that can help you win in the talent game as well too, right? And it really all depends. So I kind of want to ask you too: is there any alternative to non-competes, right? Like,
Yeah, that's a good question. So and this actually goes back to something that I kind of maybe alluded to a little bit earlier, that I probably should have explained a little bit sooner than now. Um, restrictive covenants is kind of a broad term that kind of encompasses things that you're agreeing not to do, right? It's a restriction. It's something, covenant is just an agreement. And so it's something that you're agreeing to restrict yourself from doing. A non-compete is one type of covenant within a restrictive covenant agreement. So you're agreeing not to compete in a certain amount of time within a certain distance. There's other sorts of things that might also be included in there that aren't necessarily going to be subject to the exact same restrictions as a non-compete. So generally, a non-compete has to be reasonable in terms of time, reasonable in terms of geography, and consistent with sort of the legitimate competitive business interests of the employer. And there's some other things too, but other examples might be like a non-poaching agreement, right? Where you're saying to the employee, hey, you agree not to poach my employees to go to your new employer. That really doesn't have anything to do with being in a competitive industry, right? You could leave finance to go work, for McDonald's or something like that, and it still protects as the company, right? You're still protecting your employee base by saying to that employee that left, right? You can't take any of my people with you when you go, kind of thing. You also see kind of a generic like non-solicitation where you can't solicit any of my customers. Okay, so for example, say you're an engineer, right? You work for an engineering firm and your client base is municipal. Okay, I do a lot of municipal work, so that's just the example I'm going to roll with. So say you do work with a lot of cities and townships and you're with an engineering firm and you're servicing those clients, and now you go and work in a completely unrelated industry. So what they're saying is that, okay, you can't solicit that municipal client base even for unrelated services. Okay, you can't solicit them for anything. And again, it protects that client relationship. It doesn't really restrict you from going to another engineering firm, right? You could go to a firm across town that maybe only operates in the private sector, right? Maybe they only do private development work and they don't do municipal work. Technically, it's a competing engineering firm, maybe, but as long as you're not touching those municipal clients, maybe nobody cares. Oftentimes, you do find these things in conjunction with one another, of course. So a lot of times you both are having to agree not to compete and not to solicit, and not to poach, among some other things. One thing that I've been doing a little bit more of in this sort of social media age is what I call like a non-disparagement, which prohibits you from, as the former employee, from saying like mean, nasty things online or in person about your employer to other people. So with any of these, obviously you got to be a little bit careful because there's different things, different sorts of protections maybe that could apply where you wouldn't want to interfere with somebody's rights to, say file allegations in court or with an administrative agency and stuff like that. So any of these things have to be, obviously done in conjunction with legal counsel. So you're not running afoul of any of that stuff. But I would say, I guess, in answer to your question, to kind of put a bow on this, there's any number of different things that you might want to see as the employer within a general restrictive covenant agreement. Some of those things being perhaps non-competition, non-solicitation of customers, non-poaching of current employees, perhaps no interference with things like vendor relationships or third-party contractor type relationships, and then non-disparagement, where they have to agree not to disparage or say bad things about you.
No, it's interesting because kind of sparked my mind. I was looking on LinkedIn. Obviously, we're a customer of LinkedIn, and so I spent a lot of time on there in recruiting. But to your point of the social media, I was looking at a post. It was at night. That's what I do in my off time. But looking through all these posts, and I saw one with a ton of comments, reshares, likes, all the above, and it was basically someone, an employee. They weren't there anymore, but worked at a very, very large payroll company. I won't say which one.
Yeah.
But they were kind of knocking on, hey, we don't have like all of the customer service was horrible, the pricing, the on and on and on. And I'm just thinking of being that company, and I saw the company reply to comments and everything like that. I'm like, wow,
Yeah.
it's the masses speak, right? And all that's out. Once you put it out there, it's out there forever.
You've got reach now that you never would have had before in the old days, right? In
Yeah.
the old days, I mean, what are you going to do? Write an open letter or an op-ed in the newspaper or something like that? Or like, I mean, how are you going to get that message out there? But nowadays it's so publicly available and there's such broad reach to be able to say whatever you want. It may or may not be truthful. So I think those are very legitimate concerns for employers. Again, with some of this stuff, especially when you're talking about like restricting somebody's speech, I do think you probably have to be a little careful about how you frame that. You don't want to run afoul of any administrative agencies, specifically the National Labor Relations Board,
Yeah.
which could view that as a restriction on protected rights and things of this nature. So you do have to be careful with some of that stuff, but there's definitely a legitimate interest in making sure that sort of, your former employees are not making untruthful, disparaging, statements about you in the public sphere, especially if you're like a really public facing business where that reputation is going to matter.
Yeah, or your client facing, business facing, roles that way. And I think it comes down to it on the candidate side. Sometimes what I hear from time to time is, hey, it's this restrictive covenant. It's like a foreign language to me, right? I don't know what's enforceable, what's not enforceable, either by law or what my previous employer is going to come at.
And what's enforceable in 2025, November as we record this is different from what we thought was going to be enforceable a year or two ago, where there were, I think, at least two government agencies over the last however many years have tried to pass rules, right? To, I think most recently, was it, I can't remember which federal agency, but they had a draft rule that was going to go into effect, and it got litigated and sort of overturned in a sense. But they continue to try to sort of generally invalidate nationally non-competition agreements. Different states have just banned them entirely.
Yeah.
Again, I would say you want to be careful about how you're talking about these things too, though, because a state where you have banned a covenant not to compete may still allow for a non-solicitation clause within an agreement. I believe the most recent federal rule was very restrictive in terms of what you could or couldn't do as the employer. And if I'm recalling correctly, I think it actually also pretty heavily restricted any agreement that even purported to impose sort of post-employment restrictions on the employee. So those things come up, it sort of depends on who's in power, right? At the time. I mean, which box does the president check, right? Which, is it a red box or a blue box? And then are they using their authority to appoint the various regulators and bureaucrats, and what are their priorities? So, I mean, you see a lot of broad policy pendulum swinging, just sort of depending on who's in office at the time. Kind of unfortunate in a sense. I mean, I would think anyways, you would like to at least have the consistency of knowing, right,
Yeah.
that, hey, this is the law for now. and not having to worry constantly about it shifting. But labor policy is something that seems to drastically change depending on who's in power.
When I used to recruit out in California, it felt like the wild, wild west out there, right? And,
Yeah.
things were changing all the time. So it's interesting. I always thought in my head, like, just on restrictive covenants, not just only about like, non-competes, what that looks like, will there be a national standard across the board, like you said, with that consistency? Or do you think, in your opinion, we'll just keep depending on state by state?
I think it would take based on the fact that I think two federal agencies now have sort of failed to address this nationally with rulemaking.
Yeah.
I do think that under the Commerce Clause, employers of a certain size could be federally restricted if Congress passed a law to that effect. I don't think you're going to see that under the current administration. It's possible that it could happen in the future, but it's hard to predict. I mean, it hasn't happened yet, right?
No.
So all this time, and it hasn't happened. So, are you going to see more states do it statewide? Maybe. I think there's probably 4, at least right now, that have almost completely prohibited it. And then there's some like Michigan that allow it, but it has to be reasonable, that kind of thing.
To what you're saying, the point before, it happens, see a lot in sales, right? Client facing, customer facing, business being brought in that way. And I think, people think, oh, well, I'm switched to a different industry in sales. Like, well, I'm selling a different product or selling a different service. I'm just going to go after all my customers. Like, I'm really not competing, with my past business, but at the same time, reading the fine lines in there, right? And seeking.
Yeah. Dude, I think sometimes where you see the bigger issues is like you work for a big company, right?
Yeah.
That has different divisions. And say you're in the, paper sales division, right?
Yeah.
And you're selling paper and office supplies. I'm thinking of a specific company. I won't say which one, but you're in the division that sells like paper and office supplies, right? But they also have another division that sells like uniform services or something like that, right? And I've not had any experience with this company, by the way. I'm just sort of picking on them as an example, I guess. But if your non-compete is worded sufficiently broadly, you can't you potentially could be restricted from joining any company that competes in any way with the current or former company, right? So, for example, I'm in paper and I go to work for a totally different company in uniforms, right? Well, they're going to say, well, wait a minute, we have that division too, and so it is a competitive business, right? So I think that's where on the front end, whether you're the employee or the employer, I think you want to have a clear understanding of what the intentions are behind the agreement, so that right, what the possibilities are into the future. So this is a conversation I have nearly constantly with clients in different industries, different matters, business deals, real estate deals, you name it. I can tell you what the document says. I can explain it to you. I can tell you what the law is on that. Can't tell you how the judge is going to rule because that's always kind of up in the air, But I can give you a sense for what the legal arguments are in support of or in opposition to a certain thing. I can't tell you what to do, right? Ultimately, it's a business decision. Understanding and knowing the landscape, knowing what the document says, what, are you going to try to negotiate to improve your position? I can help you do that. Has it been communicated to you that this is sort of an as-is situation, or this is a take it or leave it type of situation? Well, you can go back. It doesn't hurt to ask, right? So I would say, like, as the company, if an employee comes back to me and says, "Hey, I'm just going to go look elsewhere because I can't handle that level of restriction," the company could just say, "Okay, see you later." Or they could come back and say, "Okay, well, let's talk about this. Like, what are your concerns? What if we, carved out something over here, that's still sort of sad." So there's some room for discussion there, right? But it's a business decision as to what direction you want to proceed.
And usually those conversations from a candidate perspective, happening on the front end, because if they happened in, when you're working with them, or anything like that. That hiring manager, that company's going to look like, hey, why are you bringing this up? Are you potentially going to leave us, or what's this point in discussion we're talking about too, right? So, like you said,
Yeah.
it's having an understanding and transparency up front, you know, before you join the company, to make sure all parties know, up front what you actually both agreed upon. And then, moving forward from that, so everyone has a good understanding, rather than just, hey, sign a document to sign a document and check in a box.
I would say definitely the time to deal with it is going to be, when you start with the company, or as the company, when you onboard the person,
Yeah.
or even if business needs change and you have to implement some type of restrictive covenant program, in the middle of somebody's employment. There are totally legitimate reasons to do that that aren't unethical or immoral or anything like that. Maybe things have changed, or maybe, you're looking 5 years down the road and you're realizing I might need to sell the company, and it's going to make me more attractive to a potential purchaser to implement a program where certain key employees, have restrictive covenants so that they can't just walk off with the business, kind of thing. There's any number of different reasons why you might have to do that. But having that clarity, I think, at the time that you do it is important. And then knowing what your line in the sand is, right?
Yeah.
Um, is there a certain level where you can tolerate some discussion, and
Yeah.
then maybe less tolerance for that as you go up to, more and more key employees, so to speak. So I think it just depends, but it is a key component of business transition.
Yeah.
No question about it. It will impact whether or not a prospective purchaser wants to buy the business. It will impact their decision making. It might not cause them to not do it at all. It might not cause them to walk away from the deal, but it's going to impact how they view the deal. It's going to impact how they view the risk associated with the deal.
Yeah, I agree. Yeah, absolutely agree with you on all those points. It's awesome. And yeah, we've just, it comes up here and there with candidates every time. And so, um, so walk them through that, or have them seek, legal advice, or obviously, have a good understanding. That's our approach to it. And at the end of the day, I think, everyone wants to know from the candidate perspective, hey, what are they getting themselves into? How restricted or less restricted they're going to be, as, that career move is not only, about that covenant, but obviously the life change that they're going to have, career change,
Mhm.
and trajectory, they can
Yeah.
have in their career. But it's important.
I've had multiple employees reach out to me, where they got into a non-compete somehow or another, right? Maybe it was at the beginning of employment, maybe it was sometime in the middle. And oftentimes it's associated with the change in management. It might not even be an ownership issue. A lot of times it's just, hey, my immediate supervisor has changed and the person hates me and we don't get along and it's the
Yeah.
worst and I hate my life and blah, blah, blah. And so now I'm looking elsewhere. So from the company perspective, I think you have to seriously take into account, okay, what's going on there just within my organization,
Yeah.
right? You know what I mean? Like maybe I need to look at something there. Maybe this person's not an effective manager. Maybe they need to be trained up or something like that. Or maybe they just need some type of incentive or sanction for sort of bad management behavior, possibly. I don't know. Or maybe it is the employee's issue, right? Maybe their previous manager was too lax. But either way, something has happened. And I think the fact that people are starting to now ask about this and poke around about this is sort of a litmus test for something that is kind of going sideways that you kind of want to look at.
Yeah.
But when you haven't previously negotiated the situation, I've seen it work out all different sorts of ways. I know a guy who he just straight up went to his employer and said, and big employer, and he's looking to start a real small shop, and he basically said, look, this is what I'm doing. You know what I mean? I'm leaving. And he had a degree of trust and confidence in his management team. And they worked it out and it was no big deal,
Yeah.
and then he still had the non-compete. He honored it. There were some smaller clients that they just said, okay, you know what, we're not, those guys are too small for us to kind of really worry about anyway. And they just kind of worked it out and it was fine. And then the non-compete expired sort of on its natural terms. And a lot of his clients that had sort of waited around for him just kind of ended up trickling back over to him. And it was no big deal. And that's a case where it worked out really well. And good relationships were, I think, largely to do with that. I've also seen it where employee, doesn't want to say anything because they have such a low degree of trust and confidence in, the management, right? And then everything kind of in between that. But, I will say that as far as civil litigation goes, Adam, I mean, what percentage of cases do you think go to trial versus settle, if you had to guess?
I'm going to guess like 15%, maybe.
Not a bad guess. It's quite a bit lower than that, actually, in terms of cases that actually go all the way. Okay. So you might be looking at, maybe like 5% or less of cases that actually will proceed to trial. Okay, so most cases settle. Most cases settle. So I guess the question I would posit is, instead of like incurring the time and expense and cost of going through that whole process, like, wouldn't you want to just work out a deal on the front end in some way?
Yeah.
But everybody is a little bit timid, I think, about playing their hand.
If you're going to move to a different career path, different company, you don't have to tell your current employer where you're going to, right?
Right.
The level of trust broken there, and it's going to be, they're going to look at it a different way. So
sometimes these agreements actually will have clauses in them that require you to disclose the agreement to your new employer. An affirmative obligation that you shall, disclose the nature of this agreement to your new employer, kind of thing. But those sorts of things. I mean, oftentimes things can get worked out. Yeah, it's tough, man, because the litigation can just be so expensive. So if you're just sort of not to denigrate the profession or anything, but if you're just sort of your generic sort of salesperson, right? It's not like you're raking in so much cash that you can afford to just burn through thousands and thousands of dollars in legal fees, right? A lot of people, you're talking about professionals with, student loans and families and, medical things that come up or things that come up on the house, like you need a new roof or something like that. You're usually not talking about folks that can afford really substantial litigation. And so oftentimes they might tend to be a little more risk averse, right? They want to play kind of the safe route. And these are the people that you would generally see just switching industries completely, right? Going in an entirely new direction. And people that maybe are either willing to take more risk or they have sort of the money to fund, a more aggressive response. Those are the people that perhaps you're going to see, maybe taking a little more risk, I guess.
Yeah, no, exactly. I feel like we're all sometimes creatures of comfort. So, people don't want to go on that emotional roller coaster, too, right? With obviously, like you said, the legal fees and money tied up into it.
You actually just hit the nail on the head right there. The expense is only the tip of the iceberg with litigation. I mean, it can be emotionally draining for people, for sure. Document productions, responding to written requests, having to sit for, multiple hours at a time, through depositions, settlement negotiations, forced mediation. Sometimes you get in front of the judge and you're just thinking like, thank goodness we're finally here. We're going to get a decision. And then the judge just says, well, I'm going to take it under advisement and you might find out in 6 months what my ruling is on that motion. You know what I mean? And it's like, well, wait a minute. And now the client's mad at the attorneys and, it's just like, it can turn into a goat rodeo really quickly. And you really have to have some fortitude for it, if you're going to pursue a riskier route. I had a law school professor, Jack Gilbreth, who had this little paradigm he would talk about. And he had a visual aid. I wish I had it. I'd put it up on the screen. But it was a paradigm showing like, how as you go along the timeline in litigation, right? Time goes on, cost goes up, and control goes down, right? So the farther along you get, the more you have invested in the litigation and the less the less control you have over the outcome, right? Once you finally put it, right, say you go to trial, okay, at the conclusion of the trial, the case is now in the hands of the judge, the jury, or the arbitrator, or whomever, right? And they're going to decide. And they might be right, but they might be wrong.
Yeah.
And there might be two ways to view the evidence. And they're the ones that are going to decide. So you entirely lose that control the farther along you get. And then the more money and time you invest in it, the more sort of dug in you can feel into your position.
As a recruiter, that feels like a job within itself to go through all that. Okay.
Yeah. So like, I guess I would ask, like, how do you, I mean, you kind of touched on it, I think, a little bit earlier, but how do you handle it when you've got either you're recruiting for a company? I guess let's take it both ways. Say you're recruiting for a company that is going to require the candidate to sign a non-compete. How do you as a recruiter approach that when you're trying to source people to bring them in, or is it something that comes up maybe later in the conversation?
Yeah, no, I mean, there's sometimes it gets talked about, up front. A lot of times when it gets, mostly to that offer stage, right? Because in kind of recruiting talent acquisition, maybe not that's the first thing that we're thinking about, right?
Sure, sure.
Find that person first, but we'll bring that up, especially for key level or high level, key roles, substantial roles in organizations. We'll ask, what does that look like? Mostly around, the time period, time frame, and geographical restrictions and how that applies. And does that restrictive covenant apply to every individual, right, across the board of the company, or is it only to a select few? Because then, if it only relates to a select few, let's say the leadership team, or hiring for a leadership role, someone asks us about on the candidate side, the candidate seeking side, well, we can bring up, hey, the reason why it is this time frame or it is this restrictive in a sense, right? It's because of X, Y, and Z. And so the candidate has a good understanding, even though we don't know the ins and outs and all the language through it. But I think it's, key for us on the recruiting side, essentially that, the middle person to say, okay, what do you have in place? Why do you have it? Give us some sense of understanding. Because when we get this high level person on the phone, they're probably going to know because they've probably seen this before in their past and they have the experience. But if it's something, that it's a surprise to them or new to them or they haven't seen it before, well, at least we can, from our perspective, give a good understanding and the reason why you have this in place, and come from a place of essentially, positive intent that way, so that each side is both clear, informed, and we're transparent right from the start, instead of saying, "Oh, hey, yeah, we have this too," and then it's kind of an afterthought at the end.
From your perspective, best practices are, maybe it's not the first thing you bring up, but it gets brought up in the conversation pretty early.
Yeah.
And sort of, and almost like it sounded like what you were saying is that you like to be able to like explain the why behind it rather than just like presenting it as like a take it or leave it proposition.
Yeah, exactly. And I think just being that, comes down to communication, but I would say kind of the time, to talk about it. Maybe it's not in that, first initial interview. Maybe it's not even in the second interview, but when you have that candidate that you're like, okay, this is a great candidate. Let's check the references. And then we want to make a potential, offer to them, right? And then having, as a client, set up a meeting with that candidate, not only talking about, that potential offer and making sure it's a partnership both ways, it's a two-way street, but also in that conversation, not only talking about the offer letter and what it includes, but also going over all those items on the restrictive covenant. Yeah. And obviously employee benefits comes into that, and the whole package essentially comes with that. Yeah. So when a person joins, hey, you're clear from the start, rather than, oh, hey, this is another thing you have to sign when you come in. And then you go in thinking, oh, wait, was this kind of a shady approach, just to get me and then sign this? Okay, if they didn't bring it up to me before, what else are they hiding from me? Right? You don't want to have that as a person.
No, that's a great point.
Perspective. going into a new company.
So do you find that when you kind of follow that approach, when you take that strategy, do you find that most candidates are open to it, or are they questioning it, or sort of very hesitant, or how do you see that play out typically?
I think, you know, we definitely rely on the company and client at the end of the day to communicate that through. But I think when it comes to understanding, communicate fully through as much as the client can without maybe getting the attorney involved at that time, but maybe having that as an optional, saying, hey, if you really want to dig in the weeds and learn more about this, hey, we'll bring in our attorney. Shoot, you can have your attorney look at it as well too, if you want to, but make sure you have a full understanding. It's I think if you're a company bringing on that new employee, you're basically sending signals to that new employee like, hey, I'm going to, not like kind of show all my cards, but I want to make sure I want to put you in the best position possible. I think that's with our company when you do that. And so I just want to make sure you have all the resources, all the understanding, everything's out on the table. So there's nothing that you're thinking about after you join us on the back end that pops up and is going to surprise you.
Oh, I think that's a fair point. So if we flip the script now, and so that was kind of from like the company's perspective, how you approach it when you're recruiting for a company. Say you're working like directly with the candidate to play some, how does that change, or is your approach kind of the same? How do you deal with non-competes or restrictive covenants in that context?
Sometimes I feel like majority of the time, sometimes the candidate does bring that up to us saying, okay, hey, I want to make this move, but I do have this, non-compete, non-solicit, kind of scared about making a move, in the same industry or competing industries because I'm not sure how much it's going to handhold me, to that. So really on our end, bringing that up, saying a lot of open-ended questions. So, well, hey, what does that look like for you? What does it all include based off your knowledge? When's the last time you've looked at your non-compete, right? Or your non-solicit? Was it just the time that you started the company? Have you reviewed it? Who have you reviewed it with? And so asking a lot of those questions to make sure, the candidate has a full understanding and just providing them, the recommendation advice. They go seek legal counsel, legal advice if they need to. So they're fully aware of what they already have in place, what they're going to, and then, with a person like you, Brandon, okay, what's the good, bad, and the ugly, right?
Right. What's the risk?
What is the risk? So I think from our perspective, it's, it's asking a lot of those open-ended questions.
For sure.
Making sure that candidate has a good understanding, what they're knowledgeable about, what the overall view is of it. And then also asking, okay, well, have you worked along colleagues that have went to another competing business, right? And what happened to them? What did your company do?
I think that's a great way to look at the risk profile of your decision, right? I mean, have they enforced, what have they done to try and shut this down, if anything? I think that's a good point. What about when you're maybe representing somebody and you're trying to place them, and maybe they don't have a non-compete right now, but maybe the place you're trying to place them does have a non-compete. Do you find yourself in a position to kind of try and help the candidate negotiate that, or what does that look like?
Yeah, I mean, I've been in those situations before. Not a lot, to be honest. But yeah, it's saying, sometimes candidates, well, why do we have to sign this, right? What's the point of it? I've never had it before. I haven't had it in, not competing like 5 years. So why is this company asking me to do this? And so it's really relating to that candidate, saying, well, at the end of the day, client X, Y, and Z, they are a business too. They have to protect, the people, products, and processes within their business. So, I can't foresee if you end up leaving them. Obviously, I don't want any of our candidates to leave the company, but we get it. Life happens. people move, find better opportunities. But it's essentially saying, hey, they have this in place. They have it for, similar positions than what you're getting hired for. It's a standard process that they do. They have to protect their business. So the best advice is saying, hey, feel free to ask more questions about it, dig deeper into it, and go ask them on the candidate side to get a better understanding. And then, hey, if you end up, wanting to have an attorney take a look at it or seeking legal advice, go ahead and do that. I don't think it's been a really big pause or stop of saying, oh, hey, well, if they're making me sign this, then I don't even want the job, right?
So you haven't seen that then?
No,
Very much anyway. Yeah.
No, not
okay.
very.
Interesting.
There's some high level rules where there's,
yeah,
more executive rules where it's like, okay, they're currently employed and they're looking at opportunity. It's like, it could be something on the tipping edge to see more into. But I guess in my experience, haven't seen that quite often where it's a huge, hey,
well, and I think you get a different flavor for things too, depending on the size of the organization that you're looking to go into, because we're at the law firm. I mean, lawyers can't have non-competes anyways because it violates our ethical rules. But, just thinking of some of the other arrangements we have with people, I'm usually directly involved as managing partner with, who we're bringing on and stuff like that. And so you can get to the decision maker in our organization pretty quickly because we're a small group, right? If you're going to a large company, like maybe like a Ford Motor Company or a large sort of construction company or one of the big national engineering firms or something like that, you might hit like a policy wall, right? Where eventually whoever the hiring manager is just no longer really has authority. They maybe only have authority within a certain range. And there's some things that and as far as they're concerned are non-negotiable, and other things where they have some wiggle room. And so you could hit a wall at a larger organization at some point, right? That you wouldn't necessarily have that at a smaller place where you can ask more probing questions, get more information, and then maybe those questions lead to additional discussion where you are able to negotiate for sort of a limited scope or something like that. I think on the same vein, on the company side of things, when you're having, depending on smaller, larger, doesn't necessarily matter. It's all about what's the market for the role that you're hiring for. And if it's really competitive out there and you can make yourself more competitive as an employer, as a hirer, right, by reducing the amount of restrictions and burdens that somebody's going to have to go through during their onboarding, you might get the edge over your competition simply by having a smoother, better onboarding process where you're able to bring people in, make them feel more secure more quickly. And so I think that doesn't really necessarily relate to size, but it can. I think a lot of times smaller companies, they're trying to be even more competitive in hiring because maybe their salaries and benefits could be a little bit lower at times. They're looking at what else can they do to try and streamline things to make it so that they can bring people on more efficiently that trust them and want to stay longer.
That's the point. Any size company, what are you willing to flex and bend on, right? Is that even a discussion point to have to bring this person in, or is that just, hey, it's nothing across border? Yeah, let's tweak some things in here. And now we really, really need this person because we've had those situations before where it's like, okay, we're willing to bend on a lot, not everything, but this is the person.
That's a great point. I think it's a great point because from the company perspective, again, I do probably most of my work for businesses and organizations. So always it makes sense to talk about these things on the front end, right? Before you need to hire, before you need to bring somebody on and have them sign something. Because oftentimes what companies will do is they'll at one point in time, who knows how many years ago, they may have hired an attorney or they may have gotten, a form from the internet or whatever, or from a trade group in the industry. And they may have just been simply reusing that thing over and over again for the last however many years. And that has its own problems, right? Laws change, circumstances change, the market conditions change. business things have changed and now you haven't updated any of your documentation and you haven't maybe even had a discussion with anybody to see, does this still make sense in the way that we had it done? Or is it time for a facelift? Is it time for, a more careful tailoring of this document? And so I think for my, small businesses, for my entrepreneurs, even some large business folks that may be watching, it's time to dust this stuff off every now and again.
Yeah.
You can't just have it done one time and think that that's going to serve you. Think about your products and services, right?
Yeah.
Are you going to continue to do the products and services the same way all the time? Or no, as your business changes, obviously you're going to update those things, and your legal documents and your agreements and your employment agreements and stuff like that's really no different.
Yeah, like we've seen, I mean, throughout the past, few years, things change at a rapid pace, right? So, I mean, are you keeping with the times and updating any documents internally? Are you up to date on that? When's the last time you've had that looked at or checked out? So it's maybe something that, especially an entrepreneur, you don't really think about in the first sense, just, shove it off and all right, we're good on this, but is to constantly review any of those documents, especially when it comes to
at a minimum, even before you engage an attorney, knock the dust off of it and just read it as a layman.
Yeah.
Right. And does this still make sense? Just on an initial reading, on a layman's reading, does it still make sense? And then you can kind of go from there and determine what your budget's going to be for this and how much you want to invest in it and what you think the risk is. Have you had problems in the past? All those different things are going to factor into your business decision as to how you want to proceed from there. But at a minimum, you should be dusting this thing off and reading it every now and again, just to make sure that it's still doing what you need it to do.
Yeah, no, 100%.
So, rock and roll, man. Well, Adam, I think we'll kind of wrap it there. Thanks for being with us, and again, happy Veterans Day. Is there any social media or website or anything like that you would ask sort of the listeners to check you out at, or anything, or where do you want to point people to?
I'll definitely point people to Specialized Recruiting Group Livonia, our website. Look us up, we're on there. Connect with me on LinkedIn. Search my name, Adam Klug, Klug. Connect with any of our teammates here as well too, and go check out our posts on LinkedIn. We do a lot of fun things. We hit the gong. So
the gong.
You're in the office.
That's my favorite, guys. Adam, I guess just quickly before we wrap this whole thing up, you got to explain what the gong is so that people know what they're looking for. I love the gong.
Yeah, we're a little bit behind on videos. It's been a busy year in recruitment. No excuses. I'm a person of no excuses. So, the gong really is internally. I needed, something to celebrate wins. I thought it was going to be really, really cheesy, but really any win that we have, usually when we place a candidate into a position, we bring a new client on, someone visits our office, or really anything exciting achievements happen in the office. I embarrass myself, I bring it out, and I make people hit that gong.
No, man, I love the gong. I think it's everybody's got to have a thing, you know what I mean? And your guys' thing is the gong, and I think it's pretty cool. So, all right, cool, man. Well, thanks again, Adam, for being with us. I appreciate the discussion about sort of an interesting and kind of unique perspective that a recruiter brings to non-competes and restrictive covenants as we've talked about them. And thanks everybody for tuning in, and stay tuned because we're just pumping out more and more content, more and more episodes. And we just want to keep the business community and the communities at large that we serve and potential new clients. We want to keep everybody informed on some of the cool things that are going on with the law. So thanks again, everybody.